Welcome, everyone. Thank you so much for joining us. I'm so delighted to see everyone here and online for this roundtable on law and performance. Apologies for the slight swivel it's going to be involved in having a hybrid event, but welcome everyone watching online. This is the first Criminal Justice Centre event of the year at Queen Mary, as well as the first in a series of law and humanities events that Julie and Isabel have cooking. So do watch this space for details of future events that we're going to have. It's also, as I'm new to Queen Mary, my first event hosting, so any technical or other problems will be entirely my fault, and I take full responsibility for it. Thank you, everyone, particularly Gulch, for helping me put this together. And of course, thank you to our amazing speakers. One of the major lures for me joining Queen Mary was the richness and variety of its work in law and humanities across a range of disciplines and subject areas, as our three wonderful speakers from Queen Mary are so clearly going to demonstrate tonight. And specifically thinking about law and performance, the work that's happening here at Queen Mary in this area. So scholarship in law and performance has a long history, even if it's not always explicitly named in those terms. Anthropologists like Garfinkel were writing about rituals of degradation in the 1950s. And of course, you can go back hundreds of years to people complaining about lawyers in trials and shows. Just thinking about Julie's wonderful book, which I'll come back to, Law as Performance. And she talks about even worse than the crowd are the lawyers. Given they control the spectators, it's they who control the judges. Every day there is insolence and begging to engross the attention of the audience. Sorry, these are quotes. Superfluous and deceitful delays drawing out each case. So religious scholars in the 16th century losing their minds over the falseness of lawyers. And so we have hundreds of years, if you like, of law and performance being talked about, but there being, again, a deep ambivalence about this when it comes to on how much we take this on board in legal scholarship. So Bernard Hibberts went to the 1996 Performance Studies International Conference and gave a wonderful speech that I remember reading as an undergraduate. And he says, it almost seems that legal performance is a legal embarrassment. Not only have law's elders felt compelled to deny its existence, but they've tried to hide it from the children. So I consider one of the things we're doing here is to unhide it, bring it into plain sight. Theatre and performance in the law have much they can say and do to and with each other, verbatim and forum theatre practices, drama and legal education, the role of performance in advocacy, critical explorations around presence and liveness. The links between law and performance can enrich legal scholarship and practice, as this expert panel of speakers will do so ably demonstrate without me having to tell you about it. So what I'm going to do is I'm going to introduce our speakers each in turn. And then each person is going to speak for approximately 10, 15 or so minutes. This is loose, so do feel that you don't have to clock watch. And then we'll have time for some discussion at the end. So I'll introduce everyone first, and then I will just hand over. So first up is Julie Stone-Peters. So Julie Stone-Peters is the H. Gordon Garbedian Professor of English and Comparative Literature at Columbia, distinguished affiliated faculty at Columbia Law School, and luckily for us, a global professorial fellow here at Queen Mary School of Law. She's an expert in law and humanities, as well as performance of film and contemporary comparative media. Her most recent book is Law and Performance, Law as Performance, Theatricality, Spectatorship, and the Making of Law in Ancient, Medieval, and Early Modern Europe. And she's currently working on a book on policing, courtrooms, and prisons in the age of streaming media. Second speaker, Maggie Inchley, a reader in contemporary theatre and performance. Here we go. Here at Queen Mary. Maggie's ARC-funded collaborative project, the Verbatim Formula, with People's Palaces projects, used techniques of verbatim theatre to gather testimonies from children and adults with experience of the social care system, aiming to create spaces for dialogue and change. TVF had led to a series of residential workshops for care-experienced young people at Queen Mary and 3 other London universities. Its research is participatory and action-oriented, working with young people as co-researchers. Maggie's research also investigates the articulation of identity in contemporary writing and performance, focusing specifically on the voice, attending to how writers and their processes script voices, how vocal performance is created and delivered, and how audiences hear, listen, and respond to voices. And finally, our last speaker is Debbie Girolamo, who is a reader in law at the Centre for Commercial Law Studies, where she teaches and researches on conflict, dispute resolution, and the relationship between art and law. Debbie's also the director of CCLS's Art, Business and Law Postgraduate Program and Institute. Her current areas of research include negotiation interactions and cultural property and heritage disputes. Complementing her interest in cultural property and heritage disputes, Debbie's also interested in issues regarding law, justice, and social order as reflected through visual and performing arts. Most relevant to this event, Debbie's written on collective dissent as legal consciousness in contemporary British theatre, and she's currently developing a project on art in public spaces. So I'm going to hand over to Julie, and I realized I forgot to introduce myself. My name's Kate. Thank you for coming.
And Kate has an amazing book coming out called on pro se litigants.
Litigants in person.
Litigants in person. Yes, very, very relevant. Well, thank you to our live audience, and thank you also to all the Zoom people who maybe we can get during the Q&A. Maybe we can actually get them on the screen. So I always feel somehow that talking about law and performance comes with a kind of implicit mandate, which is perform, be entertaining. You know, it's a little bit like I've sometimes thought about teaching a course on comedy, and then I thought, all semester I have to be funny. I can't do it. Anyway, so Andreas PM of Westminster put on a half-day law and as of performance event on Friday that was incredibly entertaining, full of people doing crazy things. Andreas tied us all up with ropes, and many other things happened. So I was very relieved by the plans for this roundtable that this was supposed to be an informal conversation, zero entertainment allowed. So I promise not to entertain you. What I am going to do is just try to briefly describe my book, and then say a little bit about my current project, talk a little bit about what they share, and then maybe say something about the field of law and performance more generally if we have time, or I can do that in the Q&A. So as a lot of you know, and as Kate said, my book traces the history of law as a domain of performance from ancient Athens through the early modern period. And it is not about the representation of law in theater, as some people think. I really try to keep that at arm's length. That would be another book, and there's lots of wonderful work on it, but it's about historical, it's about historical legal events themselves as modes of representation. So it looks at law in a way that traditional legal history usually doesn't. I suspect everyone in this room looks at law in a way that traditional legal history doesn't. That is, law isn't the product just of edicts, doctrines, institutions, even sociological facts. It's the product of expressive action, and it looks at how enactment before spectators in courtrooms, judges' chambers, streets, how that actually produces law, how enactment enacts law. So it's about law as a performance practice, but it also recovers a really important tradition of legal thought that legal historians have pretty much ignored, and that is historical ideas about law as a performance practice. And what I came to realize how significant this tradition was as I got deeper into the book. And in some ways, the book captures law's love-hate relationship with its own theatricality. And it argues that love-hate relationship is in fact constitutive for law. And in a sense, it looks at one kind of slightly weird answer to the classic jurisprudential question, what is law? And the answer is not theater. You can hear the judges say, this trial is a circus. That lawyer is just indulging in theatrics. This isn't law. But of course, the book shows that at that very moment, it is. So like a lot of books, the book was a little bit of an accident. If somebody had asked me, how about you write a book about 2,000 years of legal history? I would have said, you are crazy. And in fact, it wasn't the book I was writing. I was writing a bunch of case studies that were showing methodologies for reading law as performance from the early modern period forward. So individual case studies, not a big, long history, but thought about different methodologies and tried to model them. And sometime in around 2019, I was sure the book was almost done, and I'd escaped to a friend's beach house just to, put on the finishing touches. And one of those finishing touches was just a little short mini chapter on the pre-history of the book that I'd written. And I started with a paragraph on Plato that I was obsessed with, and that paragraph got bigger and bigger and bigger and turned into a chapter. And then that chapter turned into 2 and 3. In fact, some of those chapters had to drop out, splitting and multiplying. It was really terrifying, and it kept moving me way back. I kept trying to face forward to the future and was blown backwards into history until I found myself deep in the ancient world where I had absolutely no business being. And that chapter of prehistory turned into the book. I set aside all those other written things. It was terrifying to watch it grow, and I did think I'm at the beach still, and I'll never finish it. It also COVID hit, and that was kind of good because then I had an excuse not to fly back. But I kept discovering old texts one after another where people were talking explicit, ancient and medieval and early modern texts, people talking explicitly about law as a performance practice, and weird events that showed just how weird law as performance can be. So the book turned into a kind of longue durée macro history in a sense, but it's also a micro history. It's also micro history in the sense that it looks very, very closely at certain events, so slowly and closely. And I never really thought of this before, but it's in a way a conversation about how macro history and micro history can be in conversation. Anyway, so I do still try to demonstrate some of these methodologies for close reading scenes of law. So the last event in the last chapter of the book takes place in 1678, about half a century after the original book I'd written was supposed to begin. And Peter Goodrich recently emailed me and said, when do we get the sequel? Law's Performance 1678 to God knows when. And I answered, I am not writing another 350-year history. Although I will say that one of the case, so only one piece of that original book, one of the case studies, which was on staging early modern witch trials, is actually turning into a mini monograph with Cambridge elements. So that'll be out next year. Law's Performance, but it's short, it's super short. And by the way, come by Zoom or live to Yale next weekend, where Jesus Velasco is doing this fantastic conference on witchcraft called The Craft. I'm thinking about how we craft our work too. Anyway, I am not writing that 350-year sequel, but what I am writing emerges from really the central question that the book raises, which is, why does all of this matter for law today? And the current project, the title has slightly changed since Kate probably looked at my title. It's now tentatively titled Law Before the Camera in the Age of Streaming Media. And it is, as she said, about policing, trials, and punishments in the world of 21st century media. And it's really about the convergence of camera, performance before the camera, and their streaming online. That whole axis of things that somehow function together symbiotically in tension, and et cetera, and what this means for law. And I can talk more about the specifics maybe in the discussion. So even though it's not a sequel, the two books share some central claims, and I'm going to just name some of them. The claim that although we're told we live under the rule of law, not men, you can still find this phrase with the word men in it in certain legal texts. You know, this is the central theology of modern liberal societies. We live under the rule of law, not men, but actually we don't. We live under the rule of judges and other authorities who have all kinds of private passions, caprices, appetites, attachments. Our current Supreme Court is a very excellent instance. And we all know this, but somehow our belief in the rule of law kind of marches on untouched by the knowledge that we don't really live under the rule of law. So it's one of the many contradictions that we live. Okay, second, they share the claim that lawmaking happens in the moment. It happens when a cop stops you in the street and either you resist or you don't. He charges you with REDO, resisting, delaying, or obstructing a peace officer, or he doesn't. All of those things happen at a micro level. That is where law happens too. It does happen also in bigger stories, but they share, the projects also share, and this is connected, the claim that we can't understand law if we look at it only in a very zoomed out way. We have to zoom in, we have to view it in face-to-face experience. We have to look at it closely as it unfolds in immediate time and space. And I struggle with how to describe, again and again, I try different formulations for describing what I mean by immediate time and space. And I find myself repeatedly using the word scene to describe this immediacy. And I know that I have to theorize the scene, and I haven't done it yet, but maybe some of you will help me. Anyway, They share the claim that the meaning of these kinds of scenes doesn't only lie in their outcomes. It's not only about who wins and who loses. It doesn't lie only in the doctrines they represent or even in the broad social conflicts that appear in them. But they produce all kinds of bizarre, slippery, incongruous, contradictory meanings that sort of resonate outward from small details, from objects that signify or that resonate, and that somehow work into meaning in ways that are not always on a conscious level. And I suppose in this, it's like all of us, we all do actions that are contradictory and that mean things that we don't mean them to mean and that we don't always know them to mean. And law works like that too. And also has desires like us that we don't always know, and then we realize it's a little shocking. Okay, so they also share the claim that performance and spectatorship are sites of struggle, and that sites of struggle sometimes bolster power, but they also sometimes mess with power. So the claim that we don't live solely under the rule of law, that kind of, and you know, the claim that stands against kind of what mainstream liberal law tells us, has a corollary that stands against the standard position of left critique. That is, neither do we live solely under the rule of force. We like to say, and it is certainly true, on the, you know, the classic left position is, you know, the great Robert Coverline that I find myself quoting in essentially every single talk I give, which is law takes place in a field of pain. And he says legal interpretation, and legal interpretation takes place in a field of pain and death, and it does. Law does rely on force. It does use violence and terror as one of its principal tools of domination. Subjects before the law, and this is a lot what the new work is about, are trapped by police headlights and cameras in interrogation rooms and in prison cells, but they can also use performance in front of the camera. That is, these two books share the idea that acting up matters. So both books are partly, I guess I said this on Friday, partly about the power of bad behavior. Bad behavior's power to disrupt law, but also to create law through actions. And both are about the fact that ordinary people can make law in moments of encounter. And both are about the fact that law can be, you know, deadly serious, but also histrionically bizarre, sometimes hilariously funny. Law can be tragedy, is often, maybe even usually tragedy, but can also be comedy. It can be force, but it can also be farce. Okay, how am I for time? Do I have just a couple more minutes? Okay, so as I was writing against mainstream legal history, I nevertheless realized that I was in conversation with a lot of other scholars doing allied things. And someone once asked me along the way, oh, you write about law and performance. What is the field of law and performance? And I said, it's not a field. And I think I was terrified of somehow being trapped in yet another field right now, which I'd have to kind of unpack and deconstruct. But I did realize that there were a lot of people recognizing the importance of performance to law, certainly historians, for instance, for a long time, cultural historians who write on medieval and early modern, the medieval and early modern spectacle of punishment, or historians of rhetoric who write about the importance of judicial oratory, or law and literature people writing about historic representations of law in theater as a kind of alternative domain of law making. Or in slightly more contemporary ways in which Debbie has written about, and maybe we'll hear about contemporary British theater as a form of lawmaking. And a lot of people were also doing more contemporary work. So performance practitioners using theater in restorative justice or prisons, or some of the kind of work that Maggie is going to talk about. And that there were a lot of scholars, increasing number of scholars in law and humanities generally, thinking about law as a visual, embodied, spatial, sensory, affective practice. So after I told my friend it's not a field, I happened to read an essay by Austin Serrett, who maybe some of you know is kind of the Prince of law culture and humanities in the US. And in that essay, I was shocked at a sentence. He said, the brightest future for law and humanities lies in a new interdisciplinary entity called, wait for it, this is not going to be a surprise, law as performance. And he said it's because law as performance is important because it's a way of recognizing that legal practices are actions in the world and at the same time making processes. So I thought, okay, if he says it's a field, and not only that it's a field and that it's the, new, improved, bigger and better, well, humanities, my computer is just messed up. Great, I'm writing about it. I am the brightest future. Well, that lasted about 30 seconds. But there are other people for whom it's central, people like Kate, who are helping make it a field of thought. Tempted to say field of dreams. And I am excited about the prospects of continuing to think together and to share our aspirations that in some ways are like all of law and humanities, but also distinctive. That if we look differently, if we look at law on the ground, if we look at law as felt and lived experience that emerges from expressive embodied practices, we can collectively contribute to changing the grounds that doctrine rests on.
Thank you. Thanks so much, Jill. You're going to hand over to Maggie.
I think I might need help with sharing my presentation on this computer jump to.
Yeah, if you just take us through, I'll just point of view. Got slightly too much tech.
Tech is good.
Maybe. Oh, sorry. It's okay.
And do I just press that one to make it move around?
Yeah.
Oh yeah. Okay. And I'm hoping people can see me online. Hello, people online. nice to meet you. And hello, people here in the room. Thanks for inviting me to come and speak here. It's really interesting to hear about your work. I think we've got so much in common. I'm in the drama department here at Queen Mary, and I'm just going to talk about my practice research project called the Verbatim Formula, which is a participatory project that I do with care experienced young people. And when I say care experienced young people, I mean children and young people who have to go into care, into state care. That could be foster care, it could be residential care, and now there's increasingly more and more private care, which is not always as regulated. But I'm talking about those kinds of young people for whom the law, when that happens, it's obviously intervening in their lives in a very, very felt, lived, affective way. So it is a sort of group of people about exactly whom you've been talking, Julia. Just as a background, there are some background statistics, so I won't go on about all of them, because the main thing that working with this group of young people, I've learned from that, is that they hate the alienation of the system, they feel bureaucratized, they feel dehumanized. And there is a sort of deficit narrative going on in their lives, and it's very stigmatized. They go into care and they feel bad, they feel like a failure, they feel, it's terribly stigmatized. So the actual act of going into care is in many ways just re-traumatizing in itself, because they're likely to have been in care because of some trauma happening to their family. And the most common reason for going into care is actually neglect. And of course these young people end up with lifelong mental health disorders. They suffer from, statistically, they're much more likely to be homeless, to become sex workers, to have substance abuse problems, and to end up in prison. And all of those problems are intensified by aspects such as race as well. So that's the kind of I suppose background to the situation. And then you have the whole situation with attempts to protect and defend these young people who have sometimes been a victim of abuse, and the state feels it's their obligation to protect them from further abuse, so that further laws then come in about how foster carers and social workers have to regulate really the lives of these young people. So it really is a daily experience really of the law telling you how you can live your life in a way that closes completely that gap between what we think about, you know, we believe the law is governing our lives, but these young people, it really is a lot of the time. So examples of that is, say, a person in a normal family can go off and, as mum says or dad says, or I am talking very generically, obviously, you can go off and have a sleepover. But the foster carer has to ask the social services before that young person can go for a sleepover, and or if they want to go on a school trip, there's extra checks to be done. So it just in their daily lives, they're having to cope with this awful interference, I suppose, or what they experience as an awful and embarrassing, awkward, intrusive levels of interference in their lives. And then there's all the sort of very official pathway meetings that they have to have with people who are usually strangers, where they have to tell their stories over and over again about how they went into care and all of that. And there are files that the social workers have to keep, and they write their behaviour in the files, and the young people hate that because they feel they don't have control over their own narratives. And then later on, when they want to look in their files, vast quantities of the files have been redacted, so they don't know what's happened to them. There's massive gaps in their lives. All of those things are going on. And I'm just sort of giving you those examples as sort of just lived examples of how the sort of law and the bureaucracy of those processes is having an effect on the young people. And it's ironic, really, because some of the laws are supposed to give children voices and make sure that they're listened to and they're heard. And the UK did adopt the UN Convention on the Rights of the Child in 1992, which is supposed to ensure that young people are listened to and heard and have their wishes and desires taken into account when they go into care. But of course, that isn't what the young people are experiencing. So what we do with the verbatim formula is it's sensitive and complicated work. I should say that I'm an adopted person, and one of the people that I do this research with went into foster care. So I think that does make a difference to our project, because the groups of young people we work with as co-researchers, there's a feeling of us sharing our experiences and all experiences being valid. And part of what we're doing is talking to each other more equally than the normal conversations that they have with adults, and we're sharing and supporting each other, and we're trusting. So a lot of the work that we do in our workshops together is about trust, and that's quite a slow process, and it has to be a very flexible process, and you can't just assume that the trust is going to be there by any means. But we do a lot of talking, but also playing games and having fun together and sharing stuff and getting to know each other, and that takes quite a long time. But then when we've tried to go through that process, we will then share our experiences, and that might be done in a conversation like this one, or it might be done with interviews, and that might be peer interviews where you get a very different quality of experience often than you might get from an adult interviewing a young person. Or it might be now, I mean, young people can just make a voice note. They don't even have to be with anybody. They can make a voice note and send them in, and just do it in their own time where they feel safe, etc., etc. And then what we do with our verbatim practice, which is a practice that has been more and more common, I think, in certainly in British theatre, but I think in other contexts as well. I think it's been quite commonly used in Australia, for example, as well, is we share our testimonies, and so that the person who originally spoke the testimony is sort of protected if they want their identity protected, and they can say, and they know that we're going to use this technique, so they can say whatever they want. They feel more comfortable saying whatever they want, because normally you might be in a conversation with your social worker or your foster care and you don't have any power, or you can't say, you might hurt your foster care, you don't want to say something about them, or you might be angry with your social worker because of such and such, but the social worker is not going to listen to you because you're a naughty girl or something, or you know. So the anonymizing of the testimonies has been something that's been really, really popular with the young people. And I'll just give you one of the earliest testimonies that we gathered, which is it lasts about 2 minutes, but I'm going to share it with you now, because I want to make sure that the voices of some of the young people that I work with are here. So I'll do my best. And all I'm doing is I'm listening to somebody speaking who speaks a lot faster than me, actually, normally. So I'll do my best, and I'm doing my best to say what she says as accurately as I can. Okay. There was an incident where I came back to one of my foster carers' houses, and I got there and I saw a big black taxi kind of cabby thing outside, and I thought nothing of it. And I went upstairs, and I remember my social worker being there, and my foster carer and her social worker, and like, I think there was like a police officer or something there, and they had literally packed up my stuff, and it was already in the van. Like, I walked into my room and it was already in the car, which I didn't know had my stuff in it. And there was like, you're leaving. And I was like, where am I going? And they moved me out of London at that point. And now, like I said, looking back on it, yeah, that was the best thing for me, because being in London around my friends, doing things that I wasn't supposed to be doing, absconding all the time, having people worried. Well, I can see, right, yeah, that was the right thing to do. But it would have been nice for them to speak to me about it, rather than it being a setup and me like, yo, what's going on? And do you know what I mean? Like, even my dirty laundry was packed up, and I was like, what was going on? But I think if they'd spoken to me, yeah, I probably would have, ebbed and blinded a little bit, but I would have understood. Do you know what I mean? Like, give me the chance to like, kind of, I need to feel like I'm, like you're helping me make the decision, or told beforehand, like, or had a discussion, or they just didn't do anything, and they just came and they moved me, and suddenly I was driving out, and horses and motorways, and I'm a city girl basically, and I've been here since I was 2, and that's all I know. And it was a very strange feeling for me. And the day I got there, because of the way they went on, I rebelled and went back to London from the middle of nowhere. Don't ask me how 13-year-old, 12-year-old me got from there to there, but I did. That was quite long, sorry. Yeah, often what we do, thank you. Often what we do is just ask when we share this, and I do work as part of a team. It's not just me that's doing this, but we do ask what people think and feel about what they've heard. Does anybody want to say anything?
I found it very uncanny.
Yeah.
It's very strange hearing somebody else's what's come through you.
Yeah. Yeah.
Which obviously doesn't respond to any sort of content, but it's a really interesting. I found it a very interesting process.
Yeah.
Actually.
Yeah, yeah. It's really funny when you're doing it, because it's as you sort of lose your normal sense of perception and space and other people, and you can't really tell whether you're saying anything that can be understood, because you're concentrating so hard on somebody else who's coming in through your brain. And but I do think it is uncanny, because it's like being inhabited by another person. And if you practice it, you can do it really well, obviously. But then if you practice too much, I think you start performing a character, and then it's not the person. You're not in an active listening, which I kind of like about doing it without too much of a rehearsal.
Right, without, I mean, my thought would have been that you would take these down as scripts and then read them, but that would be very, very different. Did you
People
think
do
of
it like that. I mean, people do the verbatim performance in all kinds of different ways, and some actors will learn the scripts. They'll learn them. But we do this headphone because it's easy to do with young people. It's very light on its feet. It's fun. So it's partly because it's a participatory project with young people, and we want to make sure that anyone can do it. You don't have to be an actor. Anyone can do it. Yeah.
I have a question. Is that all right, Casey?
Yeah, sorry, I've gone into questions.
Who's your target? Is it the audience and our reaction to the to what we're hearing?
Yeah.
Is it to the interviewees, to the young people who
Yeah.
are making the statements? Do they want to hear it back so that it becomes an acknowledgement,
Yeah.
validation of being heard?
Mm.
So I'm just wondering, are you
All of those.
interested in our in our reactions as part of the research project?
Totally, yeah, yes. I think it's all of those things. I think it is a validation for the young people because they're hearing their testimonies as a performance, and they're hearing people listen to them in a way that they in their daily lives that they don't always experience, or they don't experience enough really, or they're embarrassed. That experience is stigmatized and awful for them, and suddenly it's not, because it's being heard as important. But also we talk with our young people about who they want to come to the events that we do, and there's a few images there, but we have all kinds of audiences, some of them in our art centres, but some of them are audiences of foster carers and social workers, and we've done it with children's services in local authorities, and ask them what they're thinking and feeling, and then to think about the way they're dealing with young people and what they might change about it.
There's a couple of counts that I've historically been at hearings: Australian Aboriginal children taken into, and Canadian Indigenous children taken into residential care. So those accounts also, of course, had to go across not just race, ethnicity, but they also went from, if you like, a colonizer. Often the people that were doing the interviews were white, well-thinking people, but I always sort of thought there was a kind of imposition of some kind of narrative coherence into the accounts, because often people talk very disjointly, and I often sometimes thought these accounts have been slightly restructured, but you're trying to avoid that completely.
Yeah, that's interesting. Yeah, in fact, that has I'm actually quite interested in developing a project around those contacts, actually, a sort of knowledge sharing type of network, where young people's experiences would be centered, and they could talk back to those histories and challenge them a bit as well. So yes, yeah, thank you.
I'm not sure who's controlling it, but there's a chat. And I have another question.
It's just a comment. Are you finished sharing the screen?
Yeah, I mean, I'll stop. I'll probably stop there actually, because I've probably had loads of time. So what was your
Oh,
question?
I'm just sorry.
No, that's fine.
I was really interested because I can't remember what it was now you said, but it comes out a little bit more in the comment over here. I was wondering if and where and to what extent there is a question of translation going on, because I don't know that that's a really very, very, very uninformed response, but I think there has to be somewhere something translating somehow.
Yeah. Do you mean from the testimony of the young person to the event? That's
the problem. I think it's interesting to me because it's like what I thought about was if you go into events at the UN or something like that, there's people doing what you do but with different languages, so they sit there and they translate. And they're going from one language to another, and this ties back with the this different races, different ethnicities. You know that there's a translation going on. It's really easy to pin down where that's happening. This isn't. I think it must be happening here, but I can't see how.
I wonder whether reframing might be a good way of thinking about it, because an event reframes the testimony, and certainly the young person's story when they go into care, which they have to tell over and over again, is mediated by the frame of the social worker asking the questions and writing it down. And they ask things like, what's your sexual history? And, you know, and all of this, and how are you getting on at school and things. And so that's framed in that way. But then when we have our events, the testimony is reframed as the central experience. So there's a sort of a process of translation going on there. Yeah.
It was where we go. Oh, sorry.
It was so interesting watching you, because at some point it was strange watching you, because it was like, well, I should be watching you because I'm hearing somebody else speaking.
Yeah.
But at the same time, because you were also obviously listening. So,
Yeah.
you know, as I was watching you, at some point I realized I was watching somebody who's listening. And so there's an identification as well that goes on. So it was such a, I thought uncanny as well, but uncanny isn't quite it. It was very
well. It does actually make it more theatrical, doesn't it? That theatricalizes the act of listening, because you're not just listening to the words. You're looking at somebody listening, which is part of the sort of trick, I suppose, of it, because it does make people listen in a different way. I mean, when I've been to verbatim things in the theatre, which are like last hours and so on, I don't know, but I think you can sort of lose that a bit because it goes on for so long. You get used to the convention, but if you keep it quite short, and you frame it as part of a discussion, then you don't lose it. It's you know, it's that little moment is kept in the memory, you know. Yeah.
But the inflection of the different voices, I think, keeps the voices separate.
Yeah.
So you really took on that voice,
Tried.
the cadence, the sounds.
Yeah. You have to be careful not to do the accent though, because it could go into. I know, but you can't help it. You can't help it.
No,
you can't help it.
No.
But if you go too far, it becomes
Caricature.
a caricature, and so we actually sort of try not to, but you still can't help it.
No.
Especially if it's when it's an accent you're familiar with. You know.
Fascinating.
Should we move on?
Oh,
Yeah. Had so much time.
Mine won't be as fascinating as verbatim. I love verbatim theater.
Oh,
It's really interesting. I was going to ask you if you're going
can be
to turn this into a, come back here.
Really?
Are you going to come back? Are you going to make that? Are you going to be doing verbatim theater from these bits and pieces? You're going to create a theater piece?
Well, we haven't. We haven't done a sort of hour-long or 2-hour-long play. We haven't made a play out of it, but we have
London
done.
Road.
No, we haven't done that. But we have made a lot of sort of site-specific performances, a lot of them, and we're doing one in next year, in the new year, which will be performed at the Foundling Museum.
Okay.
So,
let us know.
Yeah, we'll let you
know.
I'll let you all know. Yeah.
That'd be great.
Yeah.
Okay. So when I was thinking about what to speak about today, certainly my theater piece, given its law performance. But what I thought I would do is I'm not going to take you through a discussion about legal consciousness and collective dissent, but rather approach it, give you a little bit about the piece, about the project that I worked on regarding theater and law, and talk about some of the difficulties, the complexities of writing the piece, because it was a difficult piece to write. It took me a lot of time. I enjoyed the research immensely, but then the bringing together the analytical framework and the writing, not so easy. So this was a project about law and theater. It offered a socio-legal investigation about theater performance and social constructions of law, order, and justice. In particular, it is about the messages conveyed by contemporary British theater about law and society in a particular period of time, as experienced through participant observation and textual analysis. The interpretation of meaning takes place within the legal consciousness framework of collective dissent as developed by Halliday and Morgan. Now, I decided to conduct an ethnography to get at these issues. And in the end, I realized I needed both the ethnographic observation experience to be coupled with textual analysis. And I'll explain why in a minute. Now, ethnography as a methodology has grown and has expanded greatly since the days of Malinowski. And I saw the researcher's participant role as being an audience member. And the field, Jason, you asked me about the field. The field was the stage, okay? And I proceeded on this basis. I proceeded on what were the reactions that an audience member would experience from these plays that the audience member was engaging with. Now, in terms of my observations, in terms of what it was that I was looking for, I conceived this project because I was really interested in seeing how law, justice, and social order were dealt with in the theater. So I had broad conceptions in mind when I entered the theater. So justice, legal system, legal processes, conflict, dispute resolution, you know, how was conflict being dealt with in the plays that I was seeing? Was there references to, you know, a particular legal process? So I watched the plays, I experienced the plays with this in mind. And as with many ethnographic projects, I did not go into the field with a specific research question to be answered or hypothesis to be proved. I only had these broad ideas. I did not know what I would find, if anything relevant. And that's what I really like about the ethnographic method. I really enjoy it because I'm going to be surprised. I don't know what themes and patterns are going to be exposed. And what happens is you have a eureka moment. When you're looking at your data, you're reviewing your data, and you're really getting close to your data, and you begin to see this creation of an image come out. I observed 45 plays, and there were a number of themes that emerged from the 45 plays. Initially, I categorized them. I just threw out a lot of categories: statelessness, social and legal disillusionment, crime, imprisonment and punishment, vigilantism, images of state law, rules, legislation, conflict resolution, contract arrangements, morality, justice, and justice being social and legal justice. And as I was working with the data, it became clear that underlying the themes was an image of state law being ineffectual at providing social order and therefore subject to challenge. And the data made clear a collective voice of failure, protest, helplessness, oppression, and rejection of state law. So what was I going to do with this? I'm really interested in legal consciousness, you know, the traditional theories developed by Ueck and Silby. But what I noticed was dissent was a recurring theme within these performances, with patterns of the illegitimacy of state law under challenge and alternative visions of law, pluralistic in nature, coming out of these plays. So that's what led me to collective dissent analysis, using Halliday and Morgan's conceptualization. And in so doing, what the paper did, I think, was test and further develop collective dissent as an analytical tool for examining legal consciousness for cultural legal studies. So this turned out to be a study that linked social legal studies, legal consciousness, with cultural legal studies, the theatrical performance aspect, law's performance. So just coming some of the issues I faced regarding this project. And Kate, tell me if I'm running out of time. I'll just stop whenever you tell me to. So the selection of plays, right? The initial selection, how do I choose? So I just went out. Musicals, revivals of drama plays, new plays, some West End, many off West End, really purposive. Just what was there during, it was an 8-month period of time, I think 7-month period of time. What was there? Was I available within London? And I just saw as many plays as I could. And then the second issue that I faced was, what do I do with all these plays? How do I narrow it down, right? I needed to set boundaries to the scope of the study. And what happened was, from these 45, there came to be like less than half were written by British and Irish playwrights set in a contemporary setting. There were premieres in London. Many were world premieres. A couple were like, they had a European premiere, but generally world premiere. And the theaters were all subsidized, so they had funding. And I narrowed it down even further because I was only going to use plays, I was going to study plays that had the play text. So that brought me down to about 14 plays. Another issue that I encountered was how to introduce the ethnography, the ethnographic method within this study, so that it would be what's the word I'm looking for? An accepted method, respected method, because qualitative research in law is often criticized, right? It's very different than quantitative, for example. Even though quantitative is empirical, but qualitative has a little bit of an uphill battle when we're dealing with certain studies. So I wanted to ensure that there was an understanding of ethnography. So I wanted to look at the impact that theater has and live performance has generally on audiences. So a little portion of my paper talks about that, because there's lots there, some survey and interviews with audience members talking about the impact of the theater. And that's why I also wanted the textual analysis. I wanted to be able to go to the play text, and I wanted to be able to support the observations that I had been experiencing. When I was in the project, and when I was developing the project, I had to think about, is this going to be enough, the participant observation and textual analysis? Because people were suggesting when I was presenting and, when I had workshops, and reviewers would suggest you should be interviewing playwrights and directors. You should be interviewing audience members, in addition to your observation. Or you should be watching or listening to audience reactions, or you should be conducting a survey of the audience members. But I decided I wasn't interested in their views. I was interested in what was happening on stage, interested in what was the stage telling us about these ideas that I had about law and justice and order. And as a result, it indicated a different empirical slant. I wanted to be the observer. Another problem was the structure of the data into the analysis. And I don't know if you have this any of you have these experiences, but the integration of the data into the analysis was a difficult consideration, because you want to put enough description in the paper so that people understand the analysis that you're making, but you don't want to overwhelm the paper with only description. Not easy to do. And there are, you know, if you take a look at law and cinema or television discussions about television series, you know, some people take one case study and then they'll explain whatever happened, the whole narrative, and then they talk about it. But I really didn't want to do that. So it was a question of how much description to put in and how to structure the description in the paper. So do I look at each play and talk about each of the themes within each play? And that became too burdensome. Couldn't do that. Do I look at them thematically? All right, so, okay, these are the patterns. So do I slot in all the plays thematically? Do I set out dialogue? How much dialogue do I put in? Do I just examine one play in depth? Or do I look at components of collective dissent and then speak to each with reference to the plays, which is what I did. That just made most sense to me. So that was another issue. And one other issue was the frame for analysis. Did I look at it through legal consciousness and the traditional way that Hewitt and Sylvie look at it? But I decided I couldn't because that they're really embedded within a legitimacy of the law. So the three categories are embedded in the legitimacy of the law. I didn't see legitimacy of the law in what I had observed. Legality, right? Do I look at it? Do I look at it from a perspective of legality? You know, looking at alternative forms of law resistance, the place of formal law, or the operationalization of the law. But again, I did not think that the data would be sufficiently interpreted by using that theme, that framework. And so collective dissent, because it is embedded in an illegitimacy of state law, right? And so I saw the plays as a collective, where there was collective voice and agency. And that spoke to me most, and that's what I ended up doing. So the article links, you know, social legal studies with cultural legal studies, you know, analyzing cultural media here, the theater, through the lens of a legal consciousness framework. You know, it was a difficult project, but a really rewarding one. And it's now set me on, you know, I've got two projects, one involving visual arts, but the one that I'm really, that's just sitting at the back of my mind, is I would like to do opera and law. Okay. Now that's in very, very embryonic forms, and there's just been a book out by Annunziata on opera and law, and a recent survey piece in Law and Humanities by Makura. And despite that, because these are pretty recent, and I haven't really looked deeply into what they've written, but the sense I get is that there's still room for more, because I would like to do another ethnography, but I don't know what yet. And I'm interested in contemporary opera pieces, right? I've seen a few, and I'm really interested in exploring that. And again, hooking into legal consciousness, because the whole collective dissent has actually been developed even further, away from, there's like another new kind of arm to it that is being developed. So I need to think about that further. But for now, what I'm looking at right now is I'm looking at the relationship between art and public spaces. I'm really interested in exploring concepts of legality and legal imagery arising out of art situated in public spaces. So looking at the impact of art in the maintenance of or challenges to social order. And what I'm trying to figure out right now is what is my field going to be? Is my field going to be protests, for example, because there's a lot of art in protests. I've thought about that. Is it going to be exhibitions within a particular city, within a particular period of time? Or is it going to be an ethnography of outside public spaces where I'm going to sit at Trafalgar Square and look at and see what, how people interact with art within that space. Or what does the art say within that space? I'm not sure. I'm happy to have ideas. Anyway, that's basically what I'm up to in terms of this new field. All right, it's a new field. Anyway, thank you.
Thank you so much. Okay. Thank you so much for your presentations for all of our wonderful speakers. We have time for Q&A, so I think I might
Could we maybe make the Zoom so we can actually see the participants?
yes.
I could try to
Oh,
do that
sorry.
while you answer raised hand.
So I think there might also be a couple of things in here as well. So let me just have a look.
Right, maybe, can I call on someone while you do while I make?
Yeah, so if you
that?
want to take over my job for a sec, Julie, that would be
Yeah.
great. No, please do.
So I'm super interested in the link between this, the social legal studies and the cultural, for reasons that I can't even begin to explain. I'm not going to ask the question. I'm instead going to ask the question about, which it kind of links up with Julie's work, and this might traumatize you, Julie, to ask you about scenes. But I was really interested in the potential for whether or not you felt that there was a potential, or saw any potential links with the reframing of the project here, because one of the things that struck me about what I was going to do originally was ask you to talk more about scenes, but then I thought maybe there is this, maybe you saw this possible crossover, because one of the things that really strikes me about what you were saying about scenes was how much I felt, my immediate reaction was how much I felt it spoke to my resistance and dislike of the way that the law tries to box you up and think about things and come at things in certain ways, which incidentally I think is a theme that comes out of thinking most more of you. And I have to say, I'm so much looking forward to reading all of your work, and thank you so much for the book, Julie. Which I'll wait to get to, and it's so lovely to hear three people talk about research in a way that I can relate to the problems that you have, because it's kind of like, oh, I can really super relate. It's super nice to.
You have to come to the Law and Society
I'm
Association
sure,
meetings. I'm in Canada, Canadian Law and Society, the Law and Society, Social Legal Studies Association.
For sure, I will definitely do that. But anyway, so back to but yeah, so I was really interested to hear more about the reframing, or maybe from you, Julie, the issue around the difficulty you have around scenes.
Should I start? I'll start because in a way I'm more I have historical things to say about that. And theoretical things to say about that. So I thought about it all through the book. Every time I use the word scene, I thought, what exactly do I mean by that? And I thought about it in relationship to theory of the event, what constitutes an event. An event is sort of spread out in time. So an event might be, the protests around the bombing of Palestine, so that's very, very different from what a scene is. And there's a interesting theorist named Paul Kaufman who wrote a book called Politics of the Scene. And he argued, so I don't agree with everything that he does there, but he argues that in some way, he has sort of a double argument. On the one hand, he says that politics is envisioned in scenic space initially, and it's sort of grounded in the idea of the agora, the marketplace, and that primal vision of politics, which probably also in the US, the founding fathers, a phrase I hate, envision, was always sort of undone by people like Plato, who, or I think the bad guys are Plato, Hobbes, and there's one other Plato and Hobbes are bad guys because they try to undo the politics of the scene and the kind of democratic feel that goes along with that. And the good guy is Hannah Arendt, in Kaufman's view, who I often find very annoying, in part because she's become the new Benjamin, you have to say it. And so his idea is Plato and Hobbes' authoritarianism is tied to their understanding of the politics of the scene. Arendt seeks to restore the scene in some way. So what is the scene in that sense? That's a political concept that doesn't necessarily have specific time and space. So it's helped me in a project that I did, an essay that I wrote that is supposedly done one more week on democracy and on two alternative visions of democracy, which I call, I think that the one is the too much alliteration, the performing polis and the I forget what I called it, the distributed demos, the dissociated, I couldn't find, I know it's one of those words, but basically I work sort of from Paul Kottman, but also against Paul Kottman in thinking about this as a kind of theoretical tradition of two visions of democracy that then converge problematically in our contemporary media culture, where we have videos that stand for democracy as the scene, and we have algorithms that stand for dispersed demos, and that both the promise of both of those for democracy and also the pathologies and the fears that are often associated with both of those come into conversations around the video and the algorithm. And then I talk about two recent Supreme Court cases against Google, and well, not against Google and Twitter. Yeah, kind of against Google and Twitter, but although I always forget which one and which didn't, because it's a weird thing. Anyway, that's a tangent. The main thing is, I still don't feel that I've theorized this thing that scene always implies a beginning, a middle, and an end, and it's supposed to be a beginning and a middle and an end. And I know that I am superimposing the beginning, the middle, and the end on the slices of life that I take. So basically, this is throwing it back. How can I think about this? Is there a different word that I should be using to think about how we frame things in order to analyze them, which in a way is very much in conversation with Judith Butler on frames of law, where, in a way, when she says it sounds brilliant, but it's kind of obvious. How we frame law really matters to its power and what it means. But it is, how we reframe things matters to its power.
Karen Barad's words.
Karen Barad?
Definite potential, I would say, in that regard, because she engages with Butler's work, but she talks about how this framing is productive of outcomes. I mean, I would say this because I'm relying on it very heavily at the moment. Whether or not you're prepared to go down that route is a whole other issue, but it's a possibility.
Yeah, I suppose I've got Julie, I've got a question about the limits of law. And I suppose I'll just start off with something. I'll be Calcin for a minute, right? My office used to be on the corner there and on the second floor. And I noticed that there was always, every Friday afternoon at 3 o'clock, the police would set up a checking stop. And inevitably, I'd put my watch on and say, they're going to get 15 cars, 10 of them were driven by black people.
Yeah, of course.
Sometimes I was wrong, it would be 9. Sometimes it would be 11. Now, is that the operation of the law? Because Carlson would say, how do you know that's the operation law, or that's a bunch of thugs who are being paid as policemen, but are actually engaged in corruption, right? And now, what Carlson says is you have to rationally reconstruct the scene and you tie it back through legitimacy. What were those guys legitimately doing? They only act in the scene as policemen to the extent that they're authorized. Otherwise, they act as thugs. And Carlson's famous quote, 921, if you take the mask off the political actors on the stage who claim to be legal officials, then often you just get the blood, an animal with their reawakened thirst for blood. So that's my first kind of theme of how do you know that it is law? Because if we talk about the trial, this is the old Judith Scarlett's, the political trials of the Soviet era, we don't want to say really were legal trials. They weren't legalism, that's her distinction. And then you get to say Nuremberg, where she says, well, it's a political trial, but of course it's theatre, of course it's, but it is legalistic. So she wants to have this kind of continuum. So I'm just wondering in your statement about scenes, how do you identify what law in them, and how do you identify what's corruption or brutality or just men fucking around?
I have an answer to that it's not going to satisfy you though. So first of all, one of the reasons that I don't play with that kind of legal philosophy, Kelson and Hart and so on, is that I'm never satisfied by any of the answers. So Kelson, I haven't read any Kelson in a really long time, but it's kind of a natural law framework that a lot of people who think about, Nazi law or Vichy law have used to talk about what counts as law and what doesn't count as law. Or you can take Hart, whose answer is always a kind of positivist account of it. And my view is that those, you can get foundational arguments about what counts as law and what doesn't count as law. But those foundational arguments are always going to need other foundational arguments to support them. And it's turtles all the way down, as some famous person says. Who said it? Who was it?
It was about Indonesia.
It was about Indonesia.
Turtles all the way down.
It was Clifford Garrett's, maybe? Yeah. Anyway, so and I know that maybe in some ways it's a cop-out. My work is always descriptive, and I was about to say and not normative. Of course it's secretly normative because it can't help it, but I believe that certain things are good and certain things are bad, and that creeps into the way I talk about law. But it's true that my work always has a kind of distanced, ironic, observational sense. So when you talk about legalism, that is really central to my book, legalism. But it appears as a claim or pitch or a bid for authority or for authentication rather than a distinction that I can distinguish. So that when theatricality is doing good things, I want to call it law. When it's doing bad things, I don't want to call it law. And I cannot ever come up with any normative principles that are going to help me distinguish those, other than an ethics that I've built around pretty sloppy philosophy.
I did like your section on Jan Hus, I must admit, and the chalice.
Oh, you read it?
Yeah.
Because that's really cool. That's a chapter 4.
I probably
That's
Googled
nice.
chalices. I'm trying to read a book called The Jurisprudence of Wine. And can I just make one comment?
I'll say some people know what this is about. Jan Hus, 15th century heresy trial where he was executed. And when I first started writing about it, I thought, this isn't going to work for me because it's too kind of normal legal. It's going to be just the Inquisition does these bad things to him. And that turns out to be one of my most fruitful readings, where it's wacko, where he basically, that's a perfect example of people torquing the system, taking over. He basically runs it as his own high mass, and he's of course executed in the end, but he has this kind of victorious unfrocking where he basically unfrocks them. So anyway, go on, sorry.
No, just a divvy, just an opera in law. I mean, right. Obviously, Hitler, obviously Wagner.
I thought about Das Rheingold.
Yeah. I was in Nuremberg, bizarrely, 2 weeks ago, and I was at the Colosseum, the half-built Colosseum, and bizarrely, Nuremberg Opera House is being closed for renovation for 5 years, and they decided to vote that they will put up at a cost of 140 million euros. A temporary opera house in the middle of the Colosseum. The Colosseum is the thing that, be a half built for the Nazi Party rallies. It's an enormous structure. It's only part of it, a little part of it, the documentation center. Bizarrely, part of it is the permanent home of the Nuremberg Symphony Orchestra. But they are going to put a 140 million euro temporary opera house in the middle. And it is either a stroke of genius, because you will have to make an connection between opera, fascism, and Hitler's, because Hitler was a failed artist, right? And, you know, I love the Chapman brothers' great exhibition. If only Hitler was a hippie, how happy we would have been. You know, and I don't know if you know, the Chapman brothers are contemporary British artists. They bought a whole lot of Hitler's watercolors, and they put little Mickey Mouse symbols, rainbow, and everybody gets very upset on it for some reason. But their idea was the contingencies of history and the contingencies of art. Hitler was an artist, and he was a performance artist, and he created this incredible spectacles. And if you ever watch Triumph of the Will, you can see it as a theatrical experience captured by Lenny Rippenstone. But anyway, that's just if you want to go down that route, please go to your own. Please interview some people on why they've done this.
Thank you for that.
Why they're going to do it.
I really enjoyed those three contributions, Maggie. They were wonderful. And I have loads of really specific things, but I wanted to, one of the things that came up, I suppose, for me is how different the lawyers, and Julie, you're included here, so I'm honored that's in the lawyers.
I am a member of the New York State Bar, thank you very much.
Both of you talked about observation as being a very big part of this, and in ways that put a little bit of distance between the scholar, was, you know, the writing subject, researching subject, and the object that you were researching. Different ways, both of you. But I think you both kind of said that you liked observing as kind of something that's central. And then Maggie's was so different because you were so in the midst of things, and that kind of difference didn't really make sense anymore. The idea of the observer being away from the action, as it were. And I don't really have a proper question. It was just an observation. It hit me very, very strongly. And I wonder if it is something to do with legal research, because it made me think about the ways we perform research, partly because of what you were saying, Debbie. In law, we want authority all the time. And I think we have to battle a bit to kind of, you know, show our authority in what we're doing.
Oh yeah, because for example, and I mentioned it in my article, like Lynn Mulcahy talks about the need for, you know, in cultural legal studies, that there's so many critiques made of writing and research in cultural legal studies because, you know, methodology is weak, the analytical frame is weak. So there is that you need to be careful about.
But I wondered if there's,
and that's just one area.
Yeah, there's a bit of shyness, I thought, in putting ourselves in frame. Yeah, because you just talked brilliantly just now, sort of off stage, as it were, about the writing process. Very much, you know, you were in the midst of it. But in our actual work and finished product, as it were, we're off out of the limelight.
But is it shyness? I think it's much more sinister than that. I'm sorry, this is not a personal.
No, what do you mean by sinister?
Sorry?
What do you mean by sinister? More sinister than that.
I would argue, this is not great, by the way, I think it's a super interesting observation. I'd like to catch up with you guys afterwards. Because I think that it's an attempt to avoid being accountable for your voice.
I don't know about that.
Because I think it's a restatement. I'm not saying it is, because it's a restatement of what I think is a defunct assertion of the division between subjective and objective position. So it's a restatement of an attempt at objectivity which doesn't exist.
Yeah, I have a lot of things to say about this.
No, I mean, I just, as an ethnographer, I'm both participant and observer. All right, so, and I disagree that.
Shall I give you an example about what I'm perhaps stated it so overly provocatively for the sake. So the example that I'm giving here is, so I'm working off the immediate thought that I came to when the observation was made was an example given by Karen Barat, one of our articles in my book. Barat. So the point that she made is that we have to accept that when we construct an experiment, that we are part of the experiment, and the outcome is not independent of the observer. you get a different result, you get a different outcome if you have a different observer, different experiment. So this notion that somehow there's the objectivity that's external to the experiment is false. This is the argument, because the world doesn't exist in the sense of that gulf that we have to try and span over. So she describes the example of a woman that I don't remember the name, who goes to study, I think it's one of the great apes. And she said she spent all this time trying to stand back and not be part of the grouping of the great apes. Until she realized that the great apes weren't behaving, in inverted commas, normally, because they knew that she was sitting there at the side. It was only when she walked into the middle of the group and they could see who she was and they could respond to her that they started behaving normally. So she had to acknowledge her place in the grouping that she was trying to study. And the notion of the objectivity that took her kept her to the outside was a false sense of objectivity. So it's a restatement of how you think of the world that comes into being.
So, as a practice researcher, just sort of describes completely how we work and how we have to acknowledge our own embeddedness in the and agency in the interrelational agency in the research process, because you could have a research question like, how can you use verbatim theatre blah 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 to do such, but it's meaningless, because in the process of doing that you have to establish the relationships with the young people and make them feel a certain way, or they're going to feel a certain way as a result of those relationships, which is going to affect the end of the experiment. So it's just, so what you're describing there is exactly what I find being an embedded researcher.
And I think that, it's like if you're conducting qualitative interviews, right? And the interviewer is impacting the interviewee by virtue of just being in with them. And so it's something that the researcher needs to recognize as a limitation to the data that is being obtained.
I think what's really interesting there is that concept of it as a limitation. I don't want to put words into, apologies to referencing Barat, but I don't want to put it, it's the data, the limitation is the data. It doesn't exist without the framework, if you see what I mean. I think that's the argument that she's trying to get at, which I found really challenging to engage with. So that the effort, so what I was getting, so I'm gonna make a sort of somewhat an apologetic comment and then step out of the is that when I said that I found it sinister, what I'm responding to is efforts, and I'm not making, this is not an intention to comment on you, because is the effort to try and, as it were, polish yourself out of your writing is how I, that if I understood the observation without making it personal, is that this idea of the attempt by people when they write something to assume that sort of narrative. It's the way that museums sometimes present, the curatorial voice as the voice of this is how it happened, if you sort of mean, and without acknowledging.
I hate to be the curatorial voice to leap in here.
Yeah.
So,
we're
saying no, we've run out of time. I think it's a really interesting question that we're going to have to take up after the fact. So I think actually it's a really interesting question to throw for theatre productions as well, because there are similar questions around the degrees which you make explicit how something is produced. There's
well, new museology
and museology, exactly. Unfortunately, we have to draw this part to a close, but everyone is welcome to stay in the room for longer and have some wine and some tea and coffee. Thank you so much to our speakers for a wonderful series of presentations.
And thank you so much to Kate and
and so thank you very much for everyone attending online. And I will stop this.
Thank you, everyone.
Thank you.